Good afternoon, everyone. My name is Quintanilla Williams. Welcome to the Construction Law Forum's Toolbox Talk series for this afternoon. I'm a Division I member, and I'm on the steering committee for the Toolbox. I'm on the steering committee for Division I, and I am also the chair of the Toolbox Talk series. Today, we'll be discussing prospects, pitfalls, and best practices for the use of expert witness conferencing and construction arbitration. To give you a little bit more about the Toolbox Talk series, it's a discussion we have at about noon every 6 weeks, discussing interesting topics when it comes to construction law and litigation. The moderator for today's discussion will be Marcus Quintanilla. He's an independent arbitrator, previously partner in global disputes at Jones Day, where his focus was international arbitration, with a large part of that practice being focused on construction disputes. And he will be introducing our guest speakers today, Mr. Michael Martin and Mr. Joe Rakow. You can take it from here, Marcus.
Oh, thank you very much, Quintanilla, and thanks for the opportunity to be with everyone today. Yes, first let's get on with our introductions. We have two great guests today. One is Joe Rakow. He's a group VP and principal engineer at Exponent, which is a large US-based engineering and scientific consulting firm. Some of you on this call may have used them as your experts. If so, you'll know that they do a fantastic job. Joe was one of my experts in an important arbitration, and I think just one of the best in the business. He's on the technical side, so his focus is mechanical, structural, and aerospace engineering. And he has a broad referral network, so he can just about cover any scientific or engineering area you need an expert on the field. And also with me here is one of our long-term Division I members, Michael Martin. Michael's a CPA and certified fraud examiner. He's an expert in presenting the quantum aspect of damages claims, forensic accounting, as well as compliance issues. And as you can imagine, vast expertise in delay, acceleration, disruption analyses, etc. He's worked on every kind of interesting mega project, and I think he'll have some great perspectives for us. So today, the description that Quintanilla gave was pretty dry. In fact, this is strategy in the hot tub, okay? That's a little bit sexier title. And what are we really talking about? I mean, most of you, I think, know, in a sense, what we are speaking about here. It's that terrifying moment for most US litigators when the arbitrators say, we actually want to hear from both experts at the same time, put them up there, we're going to bounce questions off of them, we're going to let them talk to each other. And the litigator, and all of us who have had, cross-examination 101 in law school know, oh my God, what could be worse than just letting this free flow discussion happen that you have no control over? But it's becoming more common, and it's extremely common in international arbitration cases. So the question for today is, what are the best practices and what are the pitfalls to avoid for counsel and for the experts themselves in the hot tubbing process? And we're going to hear from the two perspectives of the technical expert, the quantum expert, and then I'll also give my 2 cents, but hopefully we'll just have an interesting dialogue. So without further ado, Joe, give us your thoughts. The do's and don'ts and etiquette in the hot tub.
Sure. Well, thanks, Marcus. It's really nice to be here with everybody. Thank you for this opportunity. There are a lot of points to talk about. I think I will start with really sort of a baseline point, which is I try to establish a rapport with that opposing expert, and really, as you get into the hot tub and you start this dialogue, I think it's important to demonstrate for the tribunal that this isn't, you aren't taking this personally. This isn't a personal issue. This is about facts and truth, and that you respect the expert on the other side, even if you disagree with their opinions, and just sort of make sure that anything any sort of personal dynamic is really off of the table. And then if it can even be more of a proactive, positive relationship with that opposing expert, where you can demonstrate an ability to develop a rapport and to work together. I think that's just a very important baseline to establish, and then of course you get into the facts and the technical nature. But I find that to be sort of the first ingredient that I shoot for, because at that point I'm already, I know where my arguments, my sort of safe spots are. I know where my opinions are. I know what the basis for my opinions are. I know I've thought through the discussion enough to know where this thing's going to go. And I'm confident about that endpoint being consistent with what I had said before. And so just start out with getting that rapport and making sure that it's clear that this isn't a personal issue.
Yeah, I mean, the issue of rapport is a tricky one. It's in fact one of the factors that's hardest for you to control. I mean, you can control how much prep you do. You can do mooting exercises if you want. But let me press you a little bit on this, Joe, okay? Because you've made clear that you want to show the tribunal that you have professional respect for the other expert, blah, blah, blah. What if you don't have professional respect for the other expert? Because in fact, they have done a complete hack job.
Yeah.
Okay. So how do you, I mean, psychologically, and then sort of from the advocacy standpoint, how do you negotiate those things?
Yeah, so they may have done a hack job on that, and that's fine. That's going to come out in the substantive discussion, and that's the confidence that you have to have. And so, I can still, even for a person that does a hack job, I can find something to respect about that person. And so, developing that rapport and respect is I think appropriate and warranted. And then you let the discussion play out. I go into a hearing having thought about the case from a technical perspective, from every angle that I can possibly think about that, and I've thought through all of the permutations, all of the logic train that you can go through, and I certainly rely on clients to help me think through that as well. So I'm confident that the discussion, that the sort of the errors that the expert has made on the other side are going to come out as the discussion goes on, if they haven't come out already, and so. Maintaining that sort of professional atmosphere of respect, I think, is important, and the facts will come out. I believe in my favor, because I've done the work to get myself into that position.
Got it. All right. Well, thank you very much, Joe. So, Michael, what's your take on this?
Again, echoing what Joe said earlier, thank you very much for having me. Very excited for this presentation. I think my takeaway, and I agree with everything Joe said, that when you're trying to establish that rapport, one thing that I've used in the past is there's usually one thing small that you can find agreement with on the other expert, and I think it's helpful to establish that rapport where you can find some minor part of the case where you can both have agreement between the experts on, and then use that as a building block. Because I've found in testimony, especially in hot tubbing, if one expert is just saying no, and there's absolutely nothing that I did or Joe did correctly, I think that paints things in a bad light for the mediator or the judge. But where I would go with my sort of biggest takeaway is preparedness, and not necessarily preparedness of my expert report, but preparedness of how my expert report fits into the overall trial strategy or mediation strategy of the attorney, and understanding what facts and other pieces of information I need to rely upon to effectively present my expert opinion. And that two-way communication between me describing to the attorney what facts I need put into evidence to lay the proper foundation for my expert report, and also understanding where counsel wishes to use my expert report or what portions of my expert report they feel are critical to the overall case before the hot tubbing exercise is, in my opinion, vital. And so that type of preparation with the counsel prior to the hot tubbing exercise, I feel is invaluable to me as a expert witness.
Right. So you want to understand the whole story of the case. You don't want to just be siloed into your quantitative analysis. Oh, here are my assumptions, and therefore you really want to be able to echo the themes that are being developed on the facts, on the merits, right?
Yes, completely, Marcus. And because obviously, as the case progresses, the themes and the important aspects evolve. So what was the important aspects of the case at the time I prepared my expert report 6, 8, 12 months ago may no longer be the impetus of the case at this point, or the hot button piece of the case that is going to be the winning argument for our side.
And from your standpoint, how do you make that happen? That you've described an outcome, which is you want to have you as the expert on quantum, want to have a command of the narrative arc of the case, and you want to know the facts that really support which claim for which damages, right? But as a matter of, and this is the question that I'm asking you is especially useful, I think, to the litigators in the audience here, who are the ones really carrying the football. How, in your experience, is it most effective to keep you, the expert, really in the loop?
Sure. So I think it goes back to preparation and preparedness. I think if there's a team functionality within whether it's the plaintiff or the defense on the particular matter, we need to come together as a team and prepare as a team for that mediation, especially if there's going to be hot tubbing. Because again, the sort of, as you mentioned in your introduction, Marcus, when the gloves come off and the trier of fact is asking the expert direct questions, there isn't that opportunity for the counsel to present the evidence as they would want to. So I need to understand how you wish to present the evidence so that I can effectively communicate your trial strategy through my answering of the questions under that direct examination from the trier of fact. And Joe, I don't know if you have a similar experience.
Yeah, I mean, I do seek to understand, certainly the biggest picture of the case. I seek to understand the business issues that are at stake and the contractual elements that are at stake. I don't obviously get into too much of the details, but I do need to sort of understand where those hot button issues are. And my goal is to ensure that the counsel that I'm working with, that we have talked about those issues and how my opinions relate to those issues, so that we all know what the thoughts are going into the hearing. They should not be surprised by any of my answers, and that allows us to address issues that are possibly sticking points where perhaps my opinions and findings aren't particularly strong for a certain aspect of their case, and we can talk about that, how they may want to navigate and strategize around that, and figure out how to go forward. So I like to make sure that we've talked through really the sticking points, as early in the engagement as possible, and go from there.
Yeah, and I would say that one sort of checklist item you can have as counsel in these things is get the expert involved in the preparation of your opening, right? At least in most of the cases that I handled as counsel, you have an opportunity to put on a fairly robust opening presentation about what is your story, what is the evidence that's going to substantiate it. And it's, as you all know, your basic case in micro. So even though you've been working with your expert for months and maybe even years, I think it's a great idea to have them involved in several of your beta runs internally of that opening, so they are completely dialed in and they can correct you when you are overstating something or raise red flags. So there's that real symbiosis between expert and counsel at that stage. It's kind of your last chance to get everything lined up before you've committed. So, and you know, on that, just segueing from there, I guess a few other practice pointers that I would offer from the counsel standpoint. First of all, one thing I would say is going into the case, particularly if it's an international case, it's a safe assumption that hot tubbing may occur. Okay, so just have that right off the bat. And what that means is when you go choose your experts, make sure you choose experts that will be good at hot tubbing, right? It's a very specific skill. It really requires just flexibility, intellectual rigor, of course, but also, you know, an ability to understand the broader picture, an ability to understand advocacy, and candidly, a demeanor that is not overly combative and aggressive, right? Because that rapport that Joe was talking about and Michael, some human beings do not have the ability to develop this kind of rapport, particularly with someone that's on the other side of a V, right? So choosing the right expert with an eye to the likelihood of hot tubbing is a really important thing to do. And obviously there's a question at the beginning of that interview, which is tell me about your experience with hot tubbing. The second little practice pointer I would give is I think it's important as early as possible in the arbitration, I would say in the initial procedural meeting, to get as clear as possible on what the hearing format itself is going to look like. You know, as in my days as counsel, you know, I'm sure a lot of you feel the same way. Everything you do in a case is decided through the lens of how is this going to play out in cross-examination? How is this going to look at the hearing, right? And so you want to know what the rules of engagement are going to be at the hearing long before you get to the hearing, because that's going to help you prepare. It's going to help you pick your experts and everything else. So I would raise the question of whether there will be hot tubbing and what the likely format of the hot tubbing will be as soon as possible when it seems appropriate to do so. I wouldn't wait until the week before the hearing to nail down the details of how that's going to work, if you can avoid it. And there are different approaches to hot tubbing, as most of you know, but and really there's not one size fits all. A lot of it will depend on arbitrator preferences. Personally, I think a good approach is even if it's a conferenced examination, to give each expert some period of time. It could be half an hour, it could, you know, it varies one way or the other depending on the extent of the opinions being given. But the experts, I think it's very helpful for them to each give a presentation. And then for them to be given the tribunal to be given an opportunity to ask questions, followed by an opportunity for more traditional cross-examination, where you get to examine the other party's witness in a somewhat controlling closed question fashion. But even that process is much more fluid, right? You won't get away with a tight leading question because the other lawyer is going to get up and then just ask his witness, what do you think about the answer that so-and-so just gave. And it's going to easily devolve into more of a conversation. But nevertheless, I find that those three phases, expert presentation, examination by the tribunal, and then cleanup and jugular attacks by counsel can be quite effective. And I guess the third big practice pointer I would give on this is just relax a little bit. You know what? Just take a chill pill, okay? Because we're all, always white knuckle in this process because you don't know exactly how it's going to play out. But there's a flip side, which is, as I thought as counsel, and now I really see as an arbitrator, hot tubbing examination when you've got, particularly when you've got good experts like Michael, like Joe, they are so much more credible to the arbitrators, and the absorption of the information is so much more effective than in the highly artificial, controlled, structured format of a traditional cross-examination. So if you have a righteous case, you should just, and you've made a decent choice of experts, okay? I would say just try and let the process play out without overly panicking. If you have a bad case, then it's time to, maybe don't panic. You should have settled the case before the hearing. So before we turn it over to a broader discussion, any closing thoughts, Joe and Michael?
Yeah, I can go first. A couple things on presentation. So I'm a big fan of having the experts provide a presentation. I think that really moves the hearing along quite nicely. So I would push for that anytime that you can. And then the other thing, Marcus, that you mentioned was the opening presentation by the attorney. I would definitely recommend having your expert, not just participate in developing that opening, but to hear the openings from both sides. To me, when I sit and listen to that, I can tell right there what topics that cross-examination are going to focus on, what's the story that they're going to try to say. And usually, there are usually 2 or 3 nuggets in the opposing party's opening presentation that I know are directly supportive of the opinions that I've provided. And they often, the other side often doesn't realize it really when they're saying it in their opening. And so I can usually then leverage those couple nuggets later on throughout the cross-examination or hot tubbing time period. So those presentations are critical. Yeah.
And when you get those nuggets and you work them into your initial presentation, that then gives the counsel on your side ammo to work with, because sometimes he may be blocked from asking you a bunch of questions that are out of the scope of what was done already in the hot tub. So echoing your themes allows counsel then to say, Dr. Rakow, you mentioned a moment ago in your earlier presentation, X, Y, and Z. Now I'd like you to give us further, right? It just gives you an anchor to go down deeper into some of those topics. Michael, closing thoughts?
My closing thought would be echoing a little bit of what Joe and you said, Marcus, that the presentation is critical. In my mind, it allows you to play defense by playing offense first. I like to address anything that's going to be a sticking point in the testimony, or that is a bad fact or a issue that for my client, offensively in my affirmative presentation. That just allows you to diffuse it right off the bat. You're getting a first opportunity to get the trier of fact to hear your best spin on that particular topic. And I think that that's my advice for the group going forward is, have those presentations and make sure that you allot time to deal with the bad items that are in your particular set of facts, because I think it's an opportunity to diffuse them as elegantly as you can in your hot tubbing experience.
Right. And the only thing I would add to that is, all right, so what happens if the arbitrators just don't want to hear opening presentations? To be honest, that would be kind of dumb. In my view, I'd never do that as an arbitrator, but whatever. You might have some that do that. So you're still going to know what those points were that you would have liked to have made. And you're going to find a way to weave them into your essay answers to questions that you get, right? Instead of, you might not have your little moment of oratory at the beginning, but you're going to find a way to elegantly weave in those points. So let's pause right there, Quintanilla, and do we have any dialogue from the group?
Yes, we do. We have one question. It looks like someone wants to hear some war stories. What's your best and worst experience when it comes to hot tubbing?
Who wants to take that first? I'm going to tell us a Joe Rakow story, actually.
Go for it.
But Michael, you want to start?
No, go ahead. I want to hear the Joe Rakow story.
Yeah,
You said a lot.
Joe and I were on a case that involved pasteurization technology. And the pressure that would build up in the different parts of this device, and his team had put together this very beautiful animation. It was fantastic. But then there's this metal plate that's a part of the component, and there's a question about whether this thing would get so caked up with debris, the material that was being pasteurized, that it would prevent basically the steam from going in there and doing the pasteurization. And I am not an engineer, although I love engineers. I just think what's one of my favorite things is learning from them and working with them on each new technology. But we're at a certain point, people stand up, they're looking at this thing, and the expert claims that this pasteurization works one way, and I really think it should go the other way. And I pull Joe up, and we're talking, and you know how it is at a hearing, you don't have time to process complicated information. I wind up making an assertion. I get Joe up there. My assertion is scientifically false, but he finds a way to correct me and still make our point about how the pasteurization process did not work as it should have and would not work based on true scientific principles, as opposed to my scientific principles. And I thought that was just outstanding. And so get an expert like that.
Thanks, Marcus. I appreciate that. Michael, why don't you go? We've talked enough about me.
Well, interesting. We got a question in the I think war stories are great, but there's a question that Kelsey asked, and
Sure.
I think we could potentially address that.
Mm-hmm.
So, and I think this goes to the war story idea as well. Kelsey, one thing that my first hot tubbing experience, and I've had a subsequent experience the same way, is when the trier of fact wants to just meet with the experts. The trier of fact just wants the experts and just wants to be able to talk directly to the experts and see how they play off of each other. And I think that's a very interesting, the first time it happened, I was beyond shocked, because I think we had prepared for a sort of hearing type environment. But the information was presented, I think, in a very effective way. And the trier of fact's goal was to reach commonality on what do the experts agree on, and then what are the 5 or 6 things that they don't agree on. And let's cut to the chase instead of doing the presentations and the other types of arguments back and forth. Where do we agree? Where do we disagree? And let's talk about the things we disagree on. And I think that was a very unique, or at the time I thought it was unique, but it's something that I've since experienced. And I think it's a very useful and type of hot tubbing where you're really just, boiling the case down to the areas of disagreement.
Quintanilla, how much time do we have left?
We're all done. It's literally 12:30.
Okay.
But I just wanted to thank everyone for their presentation. The information was really informative and entertaining. I did put the link for the next Toolbox Talk series, which will be on June 22nd. We'll be discussing motions practice. Is it worth it in arbitrations? So please click the link and register for the next Toolbox Talk series. And with that, I think we're all set to go.
All right. Well,
Great.
thank you very much. Enjoy being with you. And thank you, Michael. Thank you, Joe.
Thank you, everybody.
Thanks,
Thank
Marcus.
you,
Thanks,
guys.
everybody.
It's great
Have a
being
great
with
day.
everyone.
All right. Yeah.
Bye.